The issues that relate in modern times to the legitimacy of investment protection, particularly through arbitration, is a matter for great concern. The major change that has taken place is that a matter that was of low visibility, not known to the public generally, has become a matter of high visibility and a matter of public protest. Why this has happened right around the world is that the system has become one that is seen as stopping a state from taking measures that are beneficial to the people of every state. Now you would find that in Bolivia, the disputes that arose concerned the right to water. The dispute in Australia, for example, concerned the protection of the health of the people that was involved in smoking. The government wanted to prevent people from smoking by indicating the hazards of smoking to the public. The arbitration system was used in order to prevent that from happening. In Spain, you would have over 20 cases brought about on the basis of tariffs that were imposed in order to regulate the alternative energy sources. In Germany, you have the same problem of the government seeking to regulate the use of nuclear utilities, or rather prevent nuclear utilities, because of the fear that such utilities might be harmful if radioactive substances were to escape. So what has been happening right around the world is that there has been a demonstration of the extent to which this system, which had so far remained a secret system that had operated without any visibility, becoming highly visible. In Ecuador, for example, the question of native rights, the rights of people living in the forests of the Amazon River were implicated when the areas of their habitation were polluted. So the major concern that has arisen, which is not confined to any part of the world, but is virtually universal, is that people are up in arms against this system which has brought about the regimentation of international norms that would hinder a state from acting to the betterment of its own people. So that's, I think, the crucial factor that has to be borne in mind. The fact that individual arbitrators, and you must remember that arbitrators who command this field can be counted on the fingers of the hands of two men. It is said that there are no more than 20 of such people. So if you look at the appointments made to the the Spanish tribunal, you would find that there is a repetition of the same names arising in the arbitration panels that have been constituted to hear the Spanish disputes. The fact is that this is a universal phenomenon. The same arbitrators, the same names keep cropping up. And the suspicion is that what has emerged is a system that is very much biased towards foreign investment protection. Because some people would dole out figures to show that states have won a certain amount of arbitrations, that this idea of bias is not accurate at all. But figures don't matter in this situation. What matters is the formulation of doctrines that have come about which are very extensive and were not intended by the states which made the treaties. To give just one example, the notion of fair and equitable treatment. When the treaties were made, and they come from 1958 on to modern times, up till 2000, no one understood what the meaning of this particular phrase was. But from 2000 and onwards, after the Argentine cases particularly, the arbitrators have tried to give a definite meaning to the fair and equitable treatment. The particularly vicious type of meaning that has been given to this phrase is the use of the idea that once you give assurance to a foreign investor, and the foreign investor has an expectation relating to the future performance of his investment, then the state must honor the assurance that has been given and not affect the expectations that the foreign investor has as to his investments. Now, one cannot find a definite basis for this interpretation. It has been sort of created over the years by a succession of arbitrators. In fact, I have suggested that one single arbitrator was instrumental in identifying this meaning, a Chilean arbitrator by the name of Francisco Orrego Vicuña. You could see a course of awards in which he was involved in the years 2000 onwards, which articulated this very specific meaning. And we see that this has become the focal point of many of the arbitral awards, the notion of legitimate expectations that have been created as a result of assurances made by a state. Now, if you look at the domestic laws of many of the countries of the world, it is pretty obvious that assurance given by a government doesn't last for a long period of time, because governments have to take into account a variety of circumstances. I think that to a large extent, private power has played a great deal in shaping the norms of investment protection. It is wrong to say that public international law is created by states alone. Public international law can be created through the use of the law order systems, law order sources of international law. By the law order sources, I mean the writings of publicists, the judicial decisions of courts, and of course arbitrators are included in it. So the reason why I say that lawyers are very powerful in the creation of a system of law in this area of investment protection through the use of law order sources is that we can see evidence of it from 1950 onwards of the employment of this technique in the creation of new norms. So you take a case like Texaco. The view of Dupuy was instrumental in the importance of stabilization clauses. And we see a course of arbitral awards that seek to bolster up the importance of stabilization clauses. It continues to the modern times because when you have a stabilization clause, a legitimate expectation is created. So this idea of Dupuy has come down continuously until this day, so that law is made by individuals, by their writings, by the words they give, and of course by lawyers who argue these cases before them. For example, you would say that the notion of what is tantamount to a taking, the expansion of that notion can be attributed to techniques of arguments that were used in NAFTA cases. like the ethyl case against Canada. When you look at the record of people who have appeared for states, that record does not seem to be very consistent. You would be able to identify certain major law firms acting consistently for foreign investors, writing their views sort of go into the literature of the law. There would be professors who would write, and very important press, but it has a specific mandate to look after the rights of of the people of Europe. That mandate doesn't exist in an investment tribunal. I mean, as the tribunal in Von Pesoid versus Zimbabwe pointed out, they are not concerned with these matters. I mean, they function on the basis of a treaty which does not mention anything about the prior history of the investment, how it affected the native people, or how it mistreated the local population. These are not matters for the investment tribunal. The investment tribunal derives its jurisdiction from the treaty which does not mention these matters. It is true that the newer treaties do mention some of these matters, and we, of course, have not had any cases arising from the newer treaties, the so-called balanced treaties. But my fear is that the balanced treaties will not work simply because of the fact that they have to be interpreted by the same arbitrators who have grown up with this system from the earlier times. Well, my problem with the court is that the court is not going to function in any better manner than arbitrators have. My fear would be that judges are also partial towards certain viewpoints. I mean, you cannot sort of take into account the European judges. The European judges, for example, if you look at the European Court of Human Rights and the manner in which it has looked at the right to property, I think they would take a viewpoint that is partial to the rights of the owner than the rights of the state, I believe, in the sense that they would probably use a proportionality analysis to measure the right to regulate against the right of the investor to right of the person to ownership of the property. So in one sense then, one might detect a tendency of courts, including the European courts, to protect property against the interests of the larger society. I mean, this is an ideological problem as well. I mean, when the European law started, they didn't have a right to property in the European Convention on Human Rights. It came later in the form of a protocol. The reason that it's given for it simply is that at that time, the socialist governments did not recognize the right to property. And over the years then, we see that the ideology has changed. The ideology has changed in order to protect the rights of the owner over the rights of the rest of the community. I think that that tendency would be greater in the investment sphere, that the judges who go into this investment court would also tend to protect the interests of the foreign investor than the interests of the state. I mean, you also have to have regard to the record of the judges of the International Court who act as judges, as arbitrators. And that's very instructive. I mean, there are several of them who have done this. I should think that they shouldn't be doing it, but you would find that they have been sitting on tribunals while being judges of the International Court. My argument is that both the ex-judges like Schwebel or sitting judges have taken views that are very pro-investor than pro-state. So if a court is constituted, I fear that the judges who sit on these courts would have a greater opportunity to fashion rules that are protective of multinational companies than protective of the right of a state to regulate. Well, technically I would favor a situation that goes back to the original system that existed in the past with the scope for arbitration in extreme circumstances where the state had transgressed obvious norms of propriety in the treatment of the foreign investor. So I would then say that the law should go back to its roots, that it should ensure that the dispute is settled through local courts, and that it is only in those circumstances where there's an exhaustion of local remedies and the court has denied a remedy in the most inappropriate way that international law steps in. And we would see that many of the solutions that are being adopted are moving in that direction. Like, say, for example, the Indian Model Treaty focuses on denial of justice. And to a certain extent, you would find that in CETA as well. I mean, though they do use fair and equitable treatment, they try to sort of confine it by using this notion of the situations that would be regarded as violations of the fair and equitable treatment. And in stating them, they're going back to old international law. So in that sense then, my suggestion would be that we go back to the roots of international law. The system is a recent system. It's not something that that has been there for ages. I mean, you can trace it from 1991 with WPL versus Sri Lanka. The world did exist, investment did exist before 1991. So this is not a great and wonderful system, and it has gone into a lot of strife at the moment. Most countries just don't want it. I mean, South Africa has done away with it. The Indians are terminating their treaties. Australians say that periodically say that they don't want investor-state dispute settlement. So why not sort of go back to the old system with this proviso that you would allow arbitration in those very atrocious circumstances where the investor has been mistreated.